Okay, right, let's go. Well, okay, thank you very much for joining the first in what will be a series of online lectures by Redline Chambers J6 group. Thank you for coming. I'm sorry it's BYOB, but hopefully you are sitting very comfortably. In about 20 minutes, you're going to hear from Nick Hall about NRM Trials and the NRM process in the context of a trial. But first, I'm going to talk a bit about defences proposed and presently available for survivors of domestic abuse who are driven to offend. I'm just going to get my slides up, hopefully. Okay, hopefully you can see my slides. Essentially, new defences have been proposed in the context of a new domestic violence bill currently wending its way through Parliament. Conceptions of what constitute domestic abuse have developed over time. Coercive and controlling behaviour is now recognised as a criminal offence as of 2015. So stakeholders are calling for a statute law to effectively catch up in terms of available defences. I'm going to consider very briefly whether that's necessary, what improvements are needed, and whether the new defences offer those improvements. I'll be skipping through a couple of slides just for the sake of time constraints, but if you want either of our slides afterwards, we will make them available to you. You may have heard of the recent-ish successful appeal by Sally Chapman. This appeal has perhaps brought into the public spotlight the impact of coercive relationships, and it is said that the lack of legal protection for survivors of domestic abuse who are driven to offend. Sally Chapman, as you probably know, killed her husband in 2010 after many years of being subjected to coercive control. Her husband would bully and belittle her, control her access to money and friends, whilst at the same time flaunting money himself and engaging in numerous affairs and the services of sex workers. If she challenged him, he would effectively gaslight her. The final straw, as it were, was when she was made to go out in the rain to get his lunch so that he could phone a woman he'd met on a dating agency with a view to meeting her. When she got back, she questioned him and was told that she shouldn't ask questions. And at that point, she struck him on the head repeatedly with a hammer. She was arrested and in an interview gave a very full account of her marriage and how she came to, in her own words, flip and kill her husband. She offered a plea to manslaughter on the basis of diminished responsibility, but that was not accepted by the prosecution. So she ran that defence at trial. The prosecution painted her as a controlling and jealous woman who planned to kill her husband, and she was convicted of murder. She was sentenced to life with a minimum of 22 years, but that was reduced to 18 years on appeal. Years later, she appealed on the basis of fresh evidence, and this was a diagnosis by a consultant forensic psychiatrist that she was suffering from 2 previously undiagnosed disorders at the time of the killing, and fresh evidence as to the alleged coercive control of the victim, and how that provided a better framework for understanding Sally Chapman's ultimate response in the context of a long history of provocation. Her appeal was allowed and her conviction was overturned, and a retrial was ordered. In June 2019, the CPS accepted her plea to manslaughter, and she was sentenced to 9 years and 4 months, meaning with time served, she was released immediately. If you read the judgment, you might know the court emphasised that they were not persuaded that had it stood alone, the general theory of coercive control on the facts as presented to the court would have afforded the appellant a ground of appeal. They also had a kind of post-conviction diagnosis of various disorders. And in that context, the theory of coercive control, as they said, may be relevant. You might also note that they expressed no view on whether the appellant was a victim of coercive control, and if she was, the extent to which it impacted on her ability to exercise self-control and on her responsibility for her actions. They also emphasised the fresh evidence was received only due to the unusual circumstances of the case, so perhaps not particularly encouraging for other convicts who want to appeal on the basis of fresh psychiatric evidence in light of greater understanding of relevant disorders or domestic abuse in general. So what's the problem? So the government data suggests that there are approximately 2.4 million victims of domestic abuse in the UK every year. That data is pre-COVID, and reports suggest that the level of domestic abuse has increased significantly during the COVID lockdown. The government itself recognises that domestic abuse is a driver in offending, and research by the Prison Reform Trust shows or indicates that almost 60% of women supervised in the community or in custody who've been assessed have experienced domestic abuse, and they suggest the figure is likely to be much higher. Disturbingly, research by the Disabilities Trust with 173 women at HMP Drake Hall found 64% of those interviewed had a history of indicative of brain injury, and for most this was caused by domestic violence. Types of offending driven by domestic violence vary widely. For example, shoplifting to support an inadequate allowance from abusive partner, coercion into fraud or holding drugs or a weapon, or defending themselves against their abuser. And for those people, women and men, whose offending is precipitated or foregrounded by their experience of domestic abuse, stakeholders have repeatedly highlighted what they say is a deficiency in the legal protection available. Current defences are unsuitable and almost certain to fail, and a new defence or an adaptation of current available defences is needed in order to plug this gap in protection for those who've been compelled to offend and those who use reactive violence against a primary aggressor. As you may know, a domestic violence bill is currently making its way through Parliament. The bill will do lots of other things of interest. For example, it will establish a statutory definition of domestic abuse that emphasises that it's not just about physical violence. It will create a statutory presumption that victims of domestic abuse are eligible for special measures in the criminal, civil and family courts. In the criminal context, as I understand it, that is based on the assumption that the victim of domestic abuse is the complainant and not the defendant. It will also restate in statute law the proposition that a person may not consent to the infliction of serious violence or their own death. There's been lots of discussion in the committee stage about the need to curtail what's known as the rough sex defence. So the Prison Reform Trust, the CBA, and others have seen this bill as an opportunity, in fact, the only foreseeable opportunity to propose new statutory defences for survivors. Admittedly, they haven't had much success so far. The government has so far opposed these proposals, and they're not persuaded that they are practical and proportionate. And they contend that all is needed is improved understanding and awareness. So as it stands, the bill has moved to the House of Lords, and these proposals are due to be tabled again there by Baroness Helena Kennedy at a date which is yet to be confirmed. So what is the proposal? The proposed new defence, one of them is directly modelled on the defence under Section 45 of the Modern Slavery Act 2015, which I think Nick will discuss when he comes to speak. The new defence seeks to afford domestic abuse survivors the same protection as a person who does an act which constitutes a criminal offence as a direct consequence of that person being a victim of slavery or human trafficking. The proposal is that the new defence is supported by a CPS policy, a general policy framework, including special measures for vulnerable defendants, and by appropriate judicial directions. As with Section 45, some offences would be excluded from this defence. The Prison Reform Trust also recommends an amendment to the law on self-defence, modelled on the provisions for householders in Section 76 of the Criminal Justice Act, Criminal Justice and Immigration Act 2008. And the idea of this is that the adaptation would allow domestic abuse survivors the same protection that is currently available to householders who act in self-defence against an intruder. And it's basically a wider definition of what constitutes reasonable force. So this is the new Section 45-esque defence as proposed, closely mirroring the defence under Section 45. I appreciate you might not be able to read this in detail and take it in right now, but I will return to parts of it in the context of what I'm about to say. And this is the proposed amendments to Section 76. So you can see it would just insert an extra few lines into subsection 5A, and would mean that reasonable force as it applies to survivors would be force that was grossly disproportionate in the circumstances. Forgive me, unreasonable force would be grossly disproportionate as opposed to just disproportionate. And there'll be a link back to the statutory definition of what constitutes domestic abuse, which is currently in clause 1 of the Domestic Abuse Bill. So are these new defences needed? There are several defences, as you probably know, available under the law already. For instance, duress, self-defence, and as partial defences to murder, diminished responsibility and loss of control. Is it a case of these being sufficient so long as they are properly considered and applied? Or is early intervention where improvements should be focused? Well, the proposals anticipate this, in fact, and include proposals, as I've said, for supporting measures which ensure domestic abuse is properly identified and dealt with in the context of criminal proceedings. The argument that Prisoners Reform Trust and others make is that additionally, and in order to assist those measures, specific defences are needed. And looking at the present situation, the obvious comparison perhaps is with the NRM process. Domestic abuse does not have an equivalent framework for identification and treatment, for want of a better word, of survivors of domestic abuse. Would that be necessary? Is that necessary? It's been argued, and this is a point that was raised in the Public Bill Committee on the 17th of June, clearly understanding of the nature of domestic abuse and of coercive control is improving, as Sally Challen's successful appeal demonstrates. I've already mentioned that the judgment makes it clear that it did not take a view on coercive control or its impact, and there are examples in the Prison Reform Trust and others' submissions of cases in which existing defences have failed domestic abuse survivors. Whilst Sally Challen's case it did in fact lead to changes to the Equal Treatments Benchbook on coercive control, the impact of her case may be less significant for less serious offences, for instance, those prosecuted in the Magistrates' Court. Advocates of the new defences argue that improved understanding will not of itself change the law, and that the law must reflect such understanding. Are the checks and balances already well established in the criminal justice process enough? Do we need these new defences? For instance, the burden and standard of proof, the possibility of half-time submissions, etc. Even would this new defence create anomalies? For instance, a full defence for a defendant who is a domestic abuse survivor, but no specific defence for defendants who were subjected to other forms of harm, such as sexual harassment from strangers. So I'm just going to look at the full defences only, so duress and self-defence, because of time and because the new proposals have been made in light of perceived deficiencies in those defences specifically. So the new Section 45-esque defence is basically duress adapted for these purposes in recognition of the experiences of survivors of domestic abuse. So what is duress, and what are the issues with the present defence of duress for domestic abuse survivors? So you may know already the following elements must be established, and these are from the case of Hassan. It must be established that the defendant reasonably believed that threats of death or GBH level injury had been made against them. It must be established that the defendant reasonably believed the threats would be carried out immediately or almost immediately, and that the threat was effective in the sense that there was no reasonable avenue of escape from the threat. It must be established that the threat or belief of the threat or death or serious violence was the direct cause of the defendant committing the offence. It doesn't have to be the only cause, but it has to be a direct cause. And finally, and what causes domestic abuse survivors perhaps the most issue, it must be shown that a sober person of reasonable firmness of the defendant's age, sex and character would have been driven to act as the defendant did. So characteristics that are, or explication of what that means exactly was set out in the case of Bowen. I've extracted those points which seem particularly pertinent to domestic abuse survivors because they demonstrate that the defence of duress may be unsuitable, but there are other elements. So Bowen states that the reasonable person will not share the defendant's vulnerability to pressure, timidity, or emotional instability. The defendant may, however, be in a category of persons who the jury may think less able to resist pressure than people who are not in that category. And as Bowen says, this includes those with recognised mental illness or psychiatric conditions, such as PTSD leading to what is known, or what was known as learned helplessness. Psychiatric evidence may be admissible to show that the defendant was suffering from such a condition to assist the jury in deciding whether a reasonable person suffering from such a condition might have been impelled to act as the defendant did. Where counsel wishes to submit that the accused had some characteristic which falls within point 2 above, this must be made plain to the judge, i.e. the judge will have to rule on admissibility first. And in most cases, according to the case of Bowen, it is probably only the age and sex of the defendant that is capable of being relevant. And if so, the judge should, as he did in that case, confine the characteristics in question to these. So for domestic abuse survivors, you may immediately see the problems faced by survivors when it comes to the defence of duress. The defence doesn't recognise psychological, sexual or financial abuse, and it fails to recognise the complexities of domestic abuse. The threat of physical harm must be imminent, and this obviously does not sit well with the typically entrenched, unpredictable and random nature of domestic abuse. The language used is outdated. Learned helplessness and concepts such as battered woman syndrome are outdated. And so the language used has failed to evolve in line with the understanding of how to prosecute, for instance, offences of control and coercion. There's a requirement to establish relevant characteristics, which means that advocates are forced to pathologise defendants rather than present a complete picture of the circumstances to the jury. The jury need to understand the incremental nature of domestic violence and domestic abuse rather than placing an emphasis on establishing a syndrome. It requires medical evidence which might not be available. This relies on a person being able to communicate to their GP and their GP understanding what they're saying. And this may be an extreme example, but Jess Phillips MP in committee gave the example of a woman reporting being strangled by her husband and being unable to breathe properly as a result, and her GP prescribing her an inhaler in response. Finally, funding and timing issues may be an issue, particularly in the magistrates' court. Can you imagine trying to get psychiatric reports in the context of a magistrate's court trial for a relatively minor offence? Does the new proposed defence ameliorate these problems? I'm not 100% sure that the kind of last few issues I've spoken to are ameliorated by the proposed defence, because the requirement to establish relevant characteristics is still there. So I'm not quite sure how the new statute alone would avoid the over-pathologisation or the risk of that. Perhaps it's a case that appropriate guidance is the solution, and indeed that is the recommendation. That's the submission by the stakeholders that want to see this new defence. Just moving on to self-defence. So, as you probably know, there are two main elements: subjective and an objective element. So firstly, did the defendant believe, or may he have believed, that it was necessary to use force to defend themselves from an attack or imminent attack? And then secondly, was the amount of force the defendant used reasonable in the circumstances? So there is some available guidance for the prosecution or for prosecution agencies when it comes to this defence and domestic abuse survivors. So the College of Policing guidance requires officers to ensure that they identify primary aggressors and avoid arresting domestic abuse survivors engaged in reactive violence, although clearly this does yet happen. The government's definition of domestic abuse is set out in the CPS Guidance on domestic abuse. That guidance appears in the main to envisage the victim of the abuse as being the complainant in the context of criminal proceedings. There's some reference in the guidance to obtaining information from the police as to the nature of the relationship between the defendant and the complainant, and to consider self-defense and counter-allegations. So there certainly is some guidance, but the evidence is that there is an inconsistent approach by the police and prosecutors where an individual's offending may be attributable to domestic abuse. And as I've said, it's argued that having effective defences on the statute book would itself prompt this investigation by directing decision makers in the criminal justice process to consider the domestic abuse context at an early stage. So, does the new defence ameliorate these concerns? Well, it is possible to bring in the background circumstances within the current law on self-defence. However, Prison Reform Trust and others assert that the defence of self-defence effectively fails domestic abuse survivors. It's very hard to fit reactive violence by survivors into the paradigm of self-defence. A jury may conclude the response was disproportionate in the circumstances, perhaps without taking into account the long history of abuse. That's the main issue, which it seems to me that the proposed amendments appear to focus on. Although they seem to focus on the idea that the reaction may be disproportionate in the circumstances, and so widen the scope of what is allowed, as opposed to focusing on the idea perhaps that such a reaction may be justified or explainable according to our ordinary standards, perhaps on receipt of medical expert evidence. Anyway, watch this space. It's not looking particularly certain that these defences will make their way onto the statute book, but wait and see. I don't think there's been much discussion as yet re the self-defence amendments, but we'll just have to wait for the House of Lords. Thank you.
Zoe, thanks for the talk. I'm now going to move on to discuss NRM trials. I'm actually in the Premier Inn at the moment. I'm mid NRM trial, so apologies if the Wi-Fi is a bit poor. We were thinking if there were any questions, I've posted it in the chat there. If anyone wants to just post a question, whether for Zoe or for me, we can deal with it at the end. And it just means we can try to make it a bit interactive. Or similarly, if anyone wants to turn on their camera, turn on their microphone and ask a question, that would also be great. Okay, I'm now going to start sharing my screen and hopefully this will work. The idea of this talk, I suppose, is a bit more informal and less legal than Zoe's, but it was really to just focus on what potential issues we might be facing as defense solicitors or defense barristers in relation to particular issues. And the idea from this talk stemmed from the fact that way back last year, I started with an NRM trial, and it is still ongoing. I'm mid-trial today. But the idea behind this presentation was, I think when the NRM process came out, everyone was like, great, we don't really understand it, but we finally got a bastion against slavery. This is going to be really useful for us as criminal practitioners. Since then, I think it's quite disappointing to report that things have very much gone downhill, which has led my title of the talk to be, yes, you're a slave, but shh, it's a secret. I won't focus too much on the NRM process, but, and I know because you're probably very aware of it, we encounter the client or you encounter the client at the local police station or in the magistrate's court. We suddenly have concerns because now we're very, very tuned into NRM and we think, well, actually, we need to make a referral. Normally, practically speaking, that involves contacting the police and or contacting the Salvation Army and saying, this is the client, I've received consent for the referral, and we are concerned that he is a victim of modern slavery. I think they're getting better at attending quicker, but Salvation Army tend to be slightly faster than the police. So from that perspective, it may be a good idea to contact them first. We'll run through it. They come back normally and say, positive grounds decision, I suspect, but can't prove that Mr. X is a victim of modern slavery. My understanding, having spoken to CPS, and the police, is that if it is mentioned in a defense statement from a lawyer that there is suspicions that they're raising the defense of NRM, that positive grounds decision is normally found to be true. It then becomes slightly more diminishing returns in relation to the conclusive grounds. But let's say for this case scenario, they come back and say, yes, on the balance of probabilities, it's accepted that Mr. X was a victim of modern slavery in the UK. And normally they specify a time, which all being well, will be the period of your offences. So we're all very positive, young criminal defence lawyers. We're like, great, we've got this wonderful decision from the government. They've recognised that my defendant is a victim of slavery. Let's send that off to the CPS and fingers crossed they will do potentially the just or the sensible thing. Unfortunately, and I don't want to be negative, I felt like Zoe's talk was quite bleak as well. That's not really the case how I think the CPS are approaching matters now. I think when the scheme was introduced, it was very much slightly new, and the CPS were very much like, well, we'll drop it. My understanding is that that's not really the case now. The law, and in fact it was considered in R&DS, I put it there, is that they are obliged to reconsider the decision. And in doing so, they must look to underlying material that has formed the decision and also the decision's reasoning. However, proceeding with that decision and deciding to prosecute is not an abusive process. That was ruled in R&DS. And I think there's now a very much general trend for the CPS to prosecute it. Unfortunately, that means that the majority of cases where you've run the NRM decision are in fact going to head to trial. But like I said, we're positive defense barristers, and we're like, it doesn't matter if we go to trial. If we don't want to, they don't want to drop it, we'll run the trial. I set out here our defense. It's section 45 under the MSA, the Modern Slavery Act. It differs depending on an adult and child, but effectively the essence of the defense is, does someone do an act and are they compelled to do it? Is that compulsion really set in this context of slavery and exploitation? And finally, a bit like duress, would a reasonable person in the same situation have done the same? And I suppose the most simple way is to give an example. Very common now is that you have a client normally running county lines. They're young, they're 16, 17, let's say 18, so they hit the section 45. They're 18 at this moment. They've been running drugs, getting paid 20 to 30 pound, 40 pound for it. But really they've been targeted, they've been exploited, and normally there's threats of physical violence if they back out. So for example, if you don't do that, I'm going to stab you. There may be production of a weapon, there may be production of a gun. So that, I think, is normally the situation we're dealing with as defense counsel. And the first 1 and 2 are usually the focus of when we take instructions. So what was this threat? What was this compulsion? And how was my client being exploited? Now, I think what is tricky and is often overlooked is the third criteria, and it's in the box there, but that is, listen, would the guy under this sort of pressure have done what he did? Would he have delivered the drugs? And looking at his characteristics, would someone similarly have done the same? Now, the real difficulty of that third limb is, if you're saying I'm being threatened and told to sell drugs, why on earth not go to the police? Sorry, Georgia Lassos, what's happening? Why on earth not go through the police? Go to the police, report your concerns, report your threats. Because what's very difficult to get home to the jury is, they're sitting there in their jury box and thinking, well, why did he go to the police? Why didn't he tell his social worker? Or why didn't he tell his probation worker that he was under threats? And therefore, the defense isn't made up. I'm sure that, listen, if I was in that position, I would have done the same thing. So that's our section 45 defense. But like, still very positive, still very upbeat. We've got this defense, it's very modern, very slave focused. It's trying to combat modern slavery. Let's take it to trial. And then we think, right, what does the CPS say about the admissibility of this decision? And look, and I've outlined the guidance there. It appears to be that they're saying, well, actually, we will allow this decision to be admitted into evidence. That is misleading as to their modern day approach. The guidance needs updating. I'm positive, I'm looking and it says, well, I put it in blue. They have this standard section 9 statement, which you'll be provided with as a solicitor, which basically outlines what the NRM process is, and it is designed to go in front of the jury. So first glance, you're like, this decision must be going in front of the jury. second glance, the NRM, the Section 9 statement's purpose is to contextualize the NRM decision by informing the defense, magistrates, judges, and juries of how the NRM operates and the evidential standard that the SCA decision makers apply. So first looking at this, you think, great, my NRM decision is going to go in. Super. Now the CPS argument on a multiple cases, my one that I'm dealing with, but also in colleagues' cases, is very much like, no, the NRM decision is just one individual. It's not expert opinion. It is inadmissible. And what their argument is not that is both the material shouldn't go to the jury, but it's also the fact that the decision came back positive is barred from going to the jury. That's their position. Now, that's why I've entitled my talk as I did. It feels very much contrary to any sort of principles of natural justice. Yes, you're a slave and the governmental body or this individual has said you're a slave, but shh, it's a secret. Everyone else in the courtroom, apart from the jury, know. Now, if you look at the law I've outlined here on whether the fact of this NRM decision is admissible is actually also quite misleading. We're still upbeat. We've looked at the guidance. We're now looking at the law. And if you look there in blue, the language is effectively saying the prosecutor is entitled to challenge the decision in front of the jury. He's entitled to rebut the statutory defense and invite the jury to come to a different decision. But that language seems to suggest that the decision itself is in front of the jury. That's quite a recent case, R&DS in 2020. But actually, the real main case that in submissions that it should be admissible is the case of R&GS. R&GS, Court of Appeals looking at a long, convoluted argument that thankfully we don't have to go into. But they also then consider the status of the NRM decision. And they consider it, and who am I to criticize the Court of Appeal, but set out an absolute dog's dinner of a response, in my view. Paragraph 69, the bit in blue, is basically saying, no way should that decision be admissible. They say that is not the case as to the admissibility of trial. We're to put it no higher. The admissibility of both the decisions in questions and the underlying reasoning must be regarded as unlikely on what may broadly, if very loosely described as this legal principle, which we don't have to go into. So here we have the Court of Appeal saying, no, not admissible. So then I think, right, well, is it even really worth getting the NRM decision? But if you read the second paragraph, they seem to have flipped round and said, had the decision and the CA minute, so basically the NRM decision, been available at the time of trial, we regard it as overwhelmingly likely that in the interest of justice and fairness, the Crown would have been required to make an admission as to the recognition of the applicant as a victim of trafficking. So that in practical terms, any admissibility difficulties at trial would have been resolved. So we stay positive. We think, great, we have this decision. It looks like here the Crown, in interest of fairness, have to accept that this decision was made and that this decision is agreed in the form of an admission. The fact of the decision is agreed in the form of an admission that goes in front of the jury, and then the Crown are free to criticize the decision as much as they want. Now, our positivity is slightly beginning to dwindle at this stage, because what the CPS are now uploading in almost all cases where they are challenging the fact that they have to make an admission as to the fact of the decision is a Crown Court case that is that of His Honour Judge Farrell in the Crown Court of Cambridge, and it's CPS and Now, it is a Crown Court case, which means it is not binding. It is merely persuasive. This case came about because His Honour Judge Farrell wished to examine more closely how valid and how detailed was the NRM referral mechanism process and the decision process. And after calling witnesses in a hearing about the NRM decision, he effectively said, it's one guy, one civil servant, one unqualified opinion. That's not an expert, so the gateways aren't admissible. And also, it is completely self-serving. Disappointing. And he says here, it is clearly the case that the legal status of the finding is that of an expression of an opinion of the body and therefore not admissible at common law. No statutory gateways. And with regard to the Court of Appeal case, which we've looked at, that's a bitter, oh bitter. He's had the advantage of having heard evidence of the process and hearing full argument at this stage of the proceedings rather than with hindsight. I take the view that the untested, predominantly self-serving nature of the information used to arrive is one of opinion evidence. So a bit disappointing there, because that is a Crown Court that has heard information about the NRM decision-making process, and to put it blunt, effectively saying it's a bit rubbish, it shouldn't go before the jury. So we've got our verdict on admissibility. We stayed super positive, but the reality is now, I don't think many Crown Courts are admitting the fact that the NRM decision came back positive. Why this frustrates me is, if you're calling your client in chief, or your client's being cross-examined, they're going to be told, well, you're not a slave, are you? You're making it up, X, like this is all a pack of lies. The first thing that should be out of their mouths and will be out of their mouths is, well, your government told me I was a slave. I've got this piece of paper saying I've had a positive decision. And if that occurs, the judge will presumably cut off the defendant and then ask the jury to disregard that comment. And although some people think it may be helpful to weasel it in that way, I actually don't think it is, because it makes your client look like he is, I don't know, exaggerating, mistaken, or attempting to deceive the court. Because ultimately what any sensible juror would think, well, is if this decision wasn't made, why am I not being told about it? If this decision was made, why haven't I been told about it? I think what I'm telling you guys now in relation to this is probably most relevant, because we all have potential clients sitting waiting for the NRM decision to come back. And we know it is a very long, lengthy process. It can take 6-7 months. So it may be, if you're pinning all your hopes on the NRM, in the hope that they drop it, or in the hope that it gets in, I think my professional advice would be, that's probably not a great call. And it may be balancing credit. It could be worth entering a guilty plea. Saying that, if you have a great case where you are clearly a slave and the Crown want to run it to trial, do so. I wouldn't suggest otherwise. Because also why I think it is relevant is in relation to sentence. If your client is convicted and he has given evidence in an NRM trial about him being super exploited, even if the jury return a not guilty verdict, they could be returning on the ground that, well, I wouldn't have done the same, I'd have gone to the police. So their guilty verdict isn't necessarily disbelieving your client, but by virtue of the NRM trial, you've managed to get a lot of evidence in front of the judge that, let's say for a drugs case, may put you from significant culpability down to lesser role. And that makes a difference in sentence. Another point and if we're going to stay positive about why the NRM decision may be helpful, is although it's not admissible at trial, it is a relevant consideration for the judge when looking at sentence, even if you plead guilty. So it does have its uses, just unfortunately not what everyone thought. It's not unfortunately how useful everyone thought it was going to be. Right, I'm going to try and continue. We only have a few more slides, so I'll run through. What I think is another particular area about NRM trials is bad character. And also this is a little bit disappointing, but my understanding is that by virtue of your client saying, I am not a slave, I cannot be compelled, the prosecution can apply under section 101 and say, we've got your previous to show in relation to this important matter and issue. So normally if you're doing a drugs trial, your bad character will need to be related to drugs. But if you're doing a drugs trial where you're running an NRM defense, I think us as instructing solicitors and barristers need to be looking at our client record again, because we may not have picked it up on the first time. We need to be looking, let's say, on a drug trial, not necessarily just for drug previous. We need to be looking at bad character goes to your defendant's character. What I mean by that is bad character such as violent offences, because the prosecution, I think, are entitled to produce evidence that your client isn't some sort of, well, mine is meek or a wallflower, but has previous for section 20 or section 18, and therefore is less likely to be a slave. Now, my view is that's a little bit short-sighted, because just because you belt someone a year before doesn't mean that you can't be a slave. So I think that's probably worth teasing out in front of the jury. My response to that application would normally be, yes, I have to concede it's relevant. We're no longer looking at propensity and type of offences are relevant. I think you have to concede it's relevant, but actually its impact is limited, and therefore it should be excluded under section 101 or under PACE. So we stay positive and we think, great, we've got the bad character excluded. And we're getting more and more positive because what we can rely on is a psychiatric report. And we can ask, or we can write an advice and ask a psychiatrist to look at specific issues that may tie into vulnerability. And that, fingers crossed, as long as they come back with some sort of recognized medical condition, will go in front of the jury. I've highlighted there perhaps in blue pertinent questions, but this type of thing would be, if I was instructing an expert, would be the type of thing that I would send to them and say, this is what I want you to consider. So I'm happy. I need to probably look at it, but I'm happy if anyone wants to look at that. For example, does X have a diagnosed mental health condition? But then I think, given what I said about the difficulties about proving, well, I would do the same thing, I wouldn't go to the police, I think the final point in blue is an important one not to miss out. Does he have any sort of mental characteristics which would make him mistrustful or reluctant to seek out legitimate forms of assistance? I.e., why wouldn't he go to the police? Like, can you look at this for me? Obviously, the report coming back may assist your case. The Crown, I think, will object to it, saying vulnerability is a jury issue. But as long as you have some sort of relevant medical condition, I think there's an argument that it should be put before the jury. Penultimate slide, duress. Now, the judge actually raised this with me. I think we need to be thinking quite clearly early on now, if we get a client, are they running modern slavery, or are they running, are we running duress? Now, before, the advantage of running modern slavery was great, we get this wonderful report and it's going to end all our troubles. No, I'm not sure actually that is the case and given delays. I suppose we now need to be considering, could we say that what we normally may classify as quite a complicated slavery argument, is that not actually just straightforward duress? So I've put the test for duress there because I think it's something we have to bear in mind. My gut is if the circumstances, I know it's not helpful, sort of smack of slavery, exploitation, vulnerability, seizing of passports, things like that, I think probably Section 45 is more appropriate. But if it's more focused on the threats rather than the terrible circumstances of the defendant, I think it's worth considering duress. If anything, it's more simple for the jury. Probably everyone says no one wins in duress, but maybe under those circumstances that would be a good idea. Bearing in mind, though, you need an imminent danger of physical injury. Perhaps an advantage of selecting a Section 45 NRM defences, well, kind of doesn't make the jury focus a bit more on the slavery aspect, and perhaps maybe it provokes a bit more sympathy. Ultimately then, we've had our trial, maybe we've had an in, maybe we haven't, it wasn't relevant. Maybe our bad character's in, maybe it's not. The jury then answer quite specific, very difficult questions that relate to the defence that I set out there. That's, I think, quite a standard route to verdict. It's probably quite easy then for us, if we're working with clients, to say, well, listen, what kind of evidence is going to help them answer those questions? So I've just set that there so people can look at it in their own time. In conclusion then, it's frustrating. Like, I accept that. I think we're all probably quite sympathetic solicitors and barristers, and we're all very attuned to slavery. The fact that we have this body that was bigged up to be so much, producing decisions that by virtue of expertise and a lack of resources aren't able to go in front of a juror, is very frustrating. But saying that, we still have a responsibility to the client and to act on their instructions. And I think I've just put a checklist here about things that we want to look for. We want to catch the referral in the first place. And what I would say is often the face of exploitation isn't just a single face. The client doesn't have to be really young and weak and emotional and needy. Often the clients who are victims of exploitation present and exhibit some sort of aggressive features that you wouldn't initially associate with exploitation. So catch the referral. We'll get our bad character responses in, and we really will try and hammer home how this is the matter and issue, but actually, is it really going to have that much of an impact on the matter and issue? So exclude it. We'll try and instruct an expert early on, and let's hope they come back with a very good medical condition and susceptibility, PTSD, or actual full-on PTSD. And then also we may think, well, is there any way we can get this evidence in about our client's vulnerability? Could we call his social worker? Could we call his probation worker? Would they be able to talk about how our client is very much susceptible to pressure and exploitation? And then we want to also think, well, should we be running duress or should we be running Section 45? One thing to say about the admissibility point is the Court of Appeals, my understanding, is looking at the issue this month. So I actually think as defense petitioners, we may be in a worse position in a few weeks' time. I think the judgment is coming out this month or early next month. If I was a betting man, I'd suggest the Court of Appeal are going to say that the fact of the decision is inadmissible. We then have to think about how we approach that. But ultimately, we deal with the client, we consider the issues, and we put our best foot forward as much as possible. just to round it off, I put some nice collage. I know we're getting towards the end of time. I'm going to stop sharing the screen, and I've just seen loads of questions, moving up questions. Mark Howie said, could I possibly get the link for the appeals? Always sorted that. Someone said, do you think the Court of Appeal can make a different, more cohesive decision on admissibility in the right case? In my view, it's outrageous that the NRM can't go in unless it's agreed. I honestly, like I'm honestly mid this trial at the moment. I am frustrated. I think it is outrageous. The Court of Appeal aren't going to change the law around. So yes, there's no gateway to get it in. It's not expert evidence. I think there is a possibility that the Court of Appeal could say, we admit the NRM's decision's failings. However, in interest of fairness to the defendant and a fair trial, I suppose, in the interest of justice, we request, or we think that it should be admitted as an admission. And then the prosecution can rip apart the decision through their OIC. And through, but there is a possibility that they may say, yes, the law doesn't let it in, but I think fairness, it should, so we're now changing the law to let it in. That is it, unless we have any burning questions or anyone wants to turn on their camera. We've got 1 minute left and ask a question. We are going to upload the talk onto the website. I've spoken to Mary, who is our wonderful Mary and Crystal assistants in Chambers PR. They, I think, are actually going to include these slides and send them out to people who attended or replied saying they attended. So hopefully you will be able to go through the slides, digest them, and like I said, our email addresses are either on the slides or it's our surnames with a dot in between at 18 Red Lion. Siobhan's asked about usually inadmissible for children. I think the same principles apply. Unfortunately, it still remains inadmissible. Potentially, what might be better there is there's a lot more pressure for the CPS to drop the case, I think, if it involves a child. And your Section 45 defence is a little bit easier in relation to the third limb and realistic alternatives. We have now hit 6:30. So have you got anything further to
add? No, I haven't got anything. No, I think that might be.
Yeah, well, guys, thanks so much for attending. I know it's all a bit weird, and normally it's a bit more fun when we can do the talk in person and a bit more casual. And I know Chambers provide alcohol for its guests. Obviously, we can't predict the future, but the moment that these type of events can be held in person, everyone is more than willing to attend. Obviously, maybe not on mass herd, but everyone is more than willing to attend Red Lion Chambers, and we can give the presentation in person and then discuss or socialize after the event in a different venue. Thanks for attending, and everyone have a good evening. Stay safe.
Thank you.